So my name is Brian Love. I'm the teaching fellow in law science and technology here at Stanford Law School, and I'm happy to report that next fall I'll be joining Santa Clara Law School as an assistant professor, so I'm definitely very excited about that. Thank you. So it's my pleasure this afternoon to introduce our final panel of the day, which I think, generally speaking, will address the topic of patent damages after the Unilock case. So to my immediate left is Professor Rich Gilbert. He's an emeritus professor of economics at UC Berkeley, where he also serves on the faculty of the Graduate School of Business. He also works as a senior consultant with Compass Lexicon, and he worked for a time with the DOJ's antitrust division, helping draft the antitrust guidelines for the licensing of IP. To his left is Darylyn Dury. She's a partner specializing in high-stakes IP litigation with her own firm, Dury Tongri, which she helped found after practicing for a number of years with Kecker and Van Nest, including about a decade as a partner there. And I think we should all congratulate her on making a really heroic effort to be here with us today. As I understand it, she's actually joining us in the middle of a ski vacation, which I suppose says something either about how much she likes patent law or how little she likes skiing. I'll let you be the judge.
Or how little snow there is.
Or how little that too. And then finally to her left is the Honorable Marilyn Huff. Judge Huff serves on the United States District Court for the Southern District of California in San Diego, which of course is one of the districts selected to participate in the patent pilot program. She was appointed to the bench in 1991 after a successful career as a civil litigator. So as you all know, last January the Federal Circuit held in Unilock that the so-called 25% rule of thumb is no longer admissible evidence for the calculation of reasonable royalty rates. So what we'd like to ask today in this panel is essentially what royalty metrics have, or at least should, fill the evidentiary void left by the departure of the 25% rule. So I think to kick off the discussion, I'll hand the reins over to Rich, who will talk a little bit about the Unilock case, sort of the rule of thumb in general, and then also sort of the idea of calculating reasonable royalty damages from economic first principles.
Well, let me just begin. First of all, can everybody hear me? Okay, if you can't, raise your hand. Speaking as an economist, and with respect to Unilock, I want to focus on this 25% rule. And as an economist, the mystery to me is why the 25% rule lasted as long as it did. As I understand it, if my history is right, this is a rule that was put forth by Mr. Robert Goldscheider years ago, and it was based on some industry aggregate data. If you look at a few industries and you draw a line, you could sort of say that somehow, on average, royalties related to 25% of some measure of profits. It was not clear what the measure of profits, appropriate measure of profits was or is today. There's enormous variation in royalty rates within an industry, which of course is the pertinent fact if you're going to actually use a rule of thumb. If actual royalty rates in your industry vary from, could be 25% of some profit measure, could be 1%, could be 30% of some profit measure. What is the value of the 25% rule? So, as a rule, I think most any economist would say, why would we even begin there? What is the point of that? What is it supposed to represent? How is it supposed to be measured? Now, if we go on and if we talk about how do we actually come up with a measure of patent infringement damages and a reasonable royalty, I just want to say, just to start the conversation going, the problem, and listening to the last panel, there's a tremendous circularity in all of this. The panel made some interesting analogies between intellectual property, patents, and real property, real estate, pointed to the problem of the transparency issue. What if you didn't know what your neighbor's house sold for? How do you figure out what your house should sell for? The analogy being, if you don't know what market transactions were for your intellectual property. In other cases, how do you know how to value the infringement of a particular patent? But I would argue that the problem is more fundamental. And the analogy that I think may be appropriate, if you want to use a real estate analogy, it's like you live in a city where all the rents are determined by a rent control board and might be too high, might be too low compared to some market value of the rents, but they're determined by the board. And that board, in my view, is, to a certain extent, it's the courts. Because if I'm negotiating a royalty arrangement for IP, what's going to be at least implicit, if not explicit, in this negotiation is if we don't come to an agreement, what's going to happen if we go to the courts, and what are the courts going to do in awarding a royalty? Well, they'll probably look at the kinds of transactions where people didn't actually go to the courts. Now, aren't we in a circularity here? If the market transactions are based on the courts, and the courts are looking at the market transactions, something doesn't seem well determined in all of this. In my view, there's need to go to fundamentals. You have to be thinking about what the source of value is for the intellectual property, what are the other sources of value that contribute to a product, what is the incremental contribution of a particular patent. Unfortunately, it's not an easy calculation, even under the most, even in the abstract, it's not an easy calculation, because if 100 patents are all essential in order to make or sell a product, then in a sense every patent holder can claim the whole value of that patent, because the whole value of the product as being the value of its patent, because the product cannot be sold without that patent. Now, when you put all of that together, it results in a logical inconsistency. It cannot be the case that everyone can be getting 100% of the value of a product. But it's a little bit like, it's the classic holdup problem that you have in real estate. I think there are some useful real estate analogies here. If you're trying to develop a property, and there's 100 parcels in the development, and they're all individually owned, you have to negotiate with every one of them, and any one can say, well, you're going to turn this property into the world's greatest, the new Disneyland. I want all the value of that. And so you get a negotiation breakdown. I have some suggestions. I suppose I should throw it out. It seems to me at one starting point for all of this, and this is particularly a problem when you have these complex products that have all these technologies all covered by different patents, all of them necessary to make or use the product. One thing a court might consider is the following. Suppose this plaintiff, the patentee, let's imagine that patentee was part of a patent pool that included all of the essential patents to make or use a product. And instead of arguing to a court over what that patentee should get for this particular infringement case, the argument were that the patentee is going to the patent pool and saying what fraction of the returns from licensing the whole bundle of patents is a reasonable and appropriate return for me with my patents or my patent portfolio. Am I saying that's an easy calculation to do? No, it's not an easy calculation to do, but it might be an anchor to get us away from this problem where, particularly for patents, multiple patents reading on the same product or device, each patent holder has in some sense too much bargaining power. And going to the market doesn't help us all that much, because the market A, is not very transparent, and B, even if it were transparent, it's so much dependent on what happens in the courts.
But what if we said, if we looked at RescueNet, and at least the Fed Circuit there said, well, in that case, the most reliable license came out of litigation. So let me ask Darylyn, what do you say about that, the litigation settlement being a proper model for patent damages, pros and cons?
Part of what I think is so interesting is that at the same time we've seen the demise of the 25% rule, we've also effectively seen the demise of looking at these comparable royalty rates, really leaving us in this evidentiary vacuum. And I think that's part of the reason that the court was attracted to either license agreements or settlement agreements for the same patent, because it seemed like something that really could anchor this analysis. From a litigator's perspective, it's very interesting. Many of the courts clearly are troubled by the idea of requiring the parties to produce settlement agreements for fear of the chilling effect that will have on settlement negotiations, and also concerned about opening up discovery into the negotiations that led to those settlement agreements. Again, I think largely because of a concern about this chilling effect. I think, though, as a matter of sort of economics and pragmatics, there's not much difference between license agreements that are negotiated before litigation is filed and license agreements that are negotiated thereafter. I agree with Rich. Whenever you are negotiating for a license to a patent, you are always considering your next best alternative to that license. And the next best alternative is almost invariably litigation. So whether you're actually in litigation or not, you're making a number of assessments about what is likely to happen. One question that I think always presents itself is, what are your litigation costs going to be? That's a factor that you're going to take into consideration in evaluating the economics of a settlement and evaluating the economics of a pre-settlement license deal. What is the litigation risk? This, to me, is sort of the biggest issue that we're sort of all not grappling with in a really thoughtful way, because, of course, the biggest driver of settlement value in a lot of ways is what you see the litigation risk as being. You may well have a situation where you think the patent is not worth very much and therefore you're willing to pay a small amount. Conversely, you may have a situation where the patent is potentially worth a great deal, but you think you have very strong infringement arguments or very strong invalidity arguments, and you reach an agreement that risk discounts a relatively large number to become a relatively small number. And simply looking at the number that's associated with either a license agreement or a settlement doesn't tell you which of those two buckets the patent would fall into. So I think you're always thinking litigation cost, you're always thinking litigation risk, you're always thinking, of course, what are the potential damages going to be, which again, could depend on factors like whether you have a laches argument that is really extraneous to the actual value of the patented invention. You're trying to think about design arounds and what your alternatives would be in the event of an injunction, although only a concern you're likely to have in mind if your adversary is a practicing entity, a potential competitor, not something you're likely to be thinking about if it's an assertion by a non-practicing entity. And then finally, an important factor in that business dynamic is going to be who the patent holder is and what their business model is, because so much of the time it's really return on investment. And so if you've got a patent holder asserting a patent very broadly and they're able to extract even relatively low settlements with very minimal costs to them, that may lead to one set of licensing numbers different from a model where people are going to spend a lot of money in litigation and then require a commensurately higher settlement in order to make up for it. So I guess that's sort of a long-winded answer to your question, but it boils down to, I think there are a lot of problems at looking at either settlement agreements or license agreements as providing real insight into the value of the invention. There's certainly some insight there, but there's a lot of factors that go into what the number associated with a license agreement or a settlement agreement is going to be extraneous to the actual value of the patent that's being licensed. And although from a litigator's perspective, in some ways I hate to say it, I don't think the distinction between license agreements and settlement agreements really holds up in the real world.
I'm a trial judge. The Federal Circuit says only allow sound economic principles in trial. our economist is saying, well, there's some problems here. My litigator is saying there's some problems here on valuation. We just heard a wonderful patent panel on large-scale macro valuations, and they're saying, well, it's very contextual. So how do I avoid becoming reversed on appeal when as I have been, when the jury sends out a note, which actually happened, and said, could we have a bigger calculator?
We don't have enough zeros.
We don't have enough zeros. And there's been no objection to the evidence that had come in. So now what models do we use to then say, here's this expert's opinion and here's this expert's opinion, and what expert opinions are admissible at trial?
Well, having been in a litigation context, I mean, the concept of prejudicial information that is being shown to a jury is one, I'm certainly very sensitive to. And sometimes you see a trial starting off with, I've seen examples where the attorney might, in opening statement, have a chart that has a big, giant red circle in it, and that is, the defendant's revenues. And then there's a little tiny slice out of it which just says, well, that's all we're asking for. It's only
1%.
Yeah,
right?
only 1%. It's it's only $1.5 billion. Don't worry about it. And it's like, well, what does that have to do with the case? Really? I mean, the case might be about whether or not you backed into the CEO's car. So why do I have to look at the whole revenues of the company? So there is a real concern about this, particularly, in a jury. It's not a specialized jury. But on the other hand, I also find great concern that why you should limit putting forward data that may be informative, even if it's not perfect by any means.
So let me take you up on that. For many people that are in the technology area, it's pretty clear now that you're only going to get your reasoned amount based on the value of your small patent to the entire product, unless you can show the entire market value that that patent was the driver for consumer demand. So probably, of those of you who do trademark law, a lot of times in trademark cases, we've had consumer surveys showing value. Do you think now that consumer surveys are going to be done in the patent context, let me ask you, Darylyn, about to show that that particular patent on that small product is really important to the overall product?
I think you are going to see a lot more survey evidence, in part because of a lack of other things that people have to be able to point to. And we're going to have a lot of the same fights, I think, over surveys in the patent context that we've had in the trademark and in other contexts. I think what Rich is proposing is really interesting. I mean, this idea that you, as I understand it, sort of look at the product and think, if you're allocating value among all of the various features, presumably patented or not, how would you do that, and how would you analyze the sort of marginal contribution of this feature? One concern that I would have with that model is it focuses very much on, from the licensee's perspective, how much value they obtain from licensing the invention. It doesn't focus as much from the licensor's perspective about what they are giving up by virtue of licensing the invention. And in some contexts that may be appropriate. In other cases, though, if you have a competitor situation, the licensor's perspective may be very important, even if it is a reasonable royalty case, in terms of informing, if you think about a hypothetical negotiation framework, what they would be willing to do. One question I would have is, in this model, could you really look at sort of willingness to pay? What would the licensee be willing to pay for this technology, which is in some ways, I think, what Rich is getting at. But then also, on the other hand, what would the licensor be willing to take in order to account for sort of having this entity on the market Maybe a direct competitor, is that backdooring in lost profits or not? That's an interesting question. Maybe not a direct competitor, but still a case where there's going to be some indirect adverse effect on the licensor by virtue of entering into the license agreement. So I think there's going to be I hope at least people are now going to be thinking about that in an economically more rigorous way. And maybe using things like survey evidence to try to get at what the licensee would be willing to pay for this technology, what the value of it really is to the consumer, and how much it either helps them compete or helps them be able to charge more for their product.
So Darylyn, what you're saying is particularly relevant in a situation where the patent is not a patent that the patentee would have ordinarily licensed, right? I mean, if you're going to license the patent, then presumably the difference between what someone is willing to pay and what you're willing to accept isn't that big. I mean, there's obviously a gap, but it might not be that big. But if it's something where you would say, look, this patent was infringed, but I would have never licensed it. It was the crown jewels. I want to license this, and what's it worth it to you is not the same as what it's worth to me to be infringed.
Either I never would have licensed it, or I wouldn't have licensed it, but for getting a whole lot of money.
Right.
Because there's this adverse competitive effect.
But at least we could say that for those circumstances where it's, say, a non-practicing entity that isn't going to actually use this, just wants to get the money from the technology, then it might be a little easier to use that basis.
Then I think, right, and what I would say is then in my model, willingness to take is whatever you can get if you're a non-practicing entity, because your next best alternative is zero. The only way to get value out of the patent is through licensing it. And that's the question, is in some negotiations, that's not true.
Right.
So do you anticipate that you would call an expert in trial to talk to the jury about how we would do it is look at our next best alternative, a design around how much is that going to cost, or alternatively, here's some licenses that were previously done?
Right. So I would propose one way you could do it is you could have an expert who would come in and say, from the licensor's perspective, here's the impact to them of licensing the technology, which may be nothing if they're a non-practicing entity, or maybe significant if they're in litigation against a competitor. And then from the licensee's perspective, as an economic matter, maybe based on survey evidence by another expert, maybe based on simply looking at profitability, here's the benefit to the licensee of having in-licensed this technology. Here's the economic benefit of that. And now this sets at least a range in which the hypothetical negotiation can occur, assuming that you've got some gap between willingness to take and willingness to pay. I mean, obviously, you can wind up in a situation where the numbers cross, right?
Well, let's say one of the settlement licenses that you want your expert to talk about is with a third party, and that third party says, I don't want that information coming out in court. Aren't you sympathetic to the third party? They weren't a part of this litigation.
Sympathetic. I've been there. Hugely sympathetic.
What do you do?
Interestingly, we had a situation that presented this. We litigated a case on behalf of a company. The case settled. A license was taken. And then in what in our view was really unrelated litigation involving a different patent, one of the parties sought to get discovery of our settlement agreement in order to have their expert rely on it for these purposes. There was further litigation going on with respect to the patent that had been the subject of the case we settled. So we had a pretty keen interest in keeping the terms of that settlement confidential so as not to skew potential settlement negotiations with other parties. We intervened as a third party in the case in which discovery of the settlement agreement was being sought. We litigated that issue.
Successfully?
Well, so interestingly, it was in front of Judge Fogel in this district, and what he did is basically say we're going to wait. He said, I understand your concerns. I don't want to decide the discoverability/admissibility issue now. Let's let the litigation play out, and if we actually get to the eve of trial, then I'm going to hear this and decide whether the settlement agreement should be discovered at that point in time. And the case settled before it ever got to that point. But I thought that was sort of an interesting approach, although it creates timing issues, obviously, with respect to disclosure of expert reports and things of that nature.
So since it's it's somewhat unclear, I would say. It depends, there's a lot of discretion on the trial judge, whether you're going to let it be discovered, whether the third party objects or doesn't object. I was reading one of my orders and it reads redacted, redacted, redacted. And that may be the situation. And then there's evidence rules, 408, that you could argue about. And then 403, overly prejudicial. And then because each litigation is in that context, you could say even if you had a settlement, it doesn't really add to relevant information about this particular litigation. So the lessons learned here is if you're trying to avoid the production, then you can make really good arguments to the discovery judge that it's too prejudicial, it's not likely to lead to it, or you could maybe ask for phasing. We've often done the same kind of thing, phasing. Let's do maybe not a formal bifurcation, but let's do the infringement things first before we ever get to the settlement decisions. And then even if not, then you could have Daubert motions or other motions on the eve of trial or at some relevant point for the trial court to say, do these facts really match up with the facts that are in trial? Is that your experience?
I think that's exactly right. And again, because I think if you're talking about the production of, let's say you have a patent holder who sued two entities and one of them has settled and the other one has gone forward, just the reasons that you will have settled with that entity can vary. I mean, in terms of, as sort of we said, litigation costs, litigation risk, assessment of the forum that you're in. The practicalities. Maybe you've chosen to settle with one entity because you like your chances better in forum number 2. That says nothing about the value of the IP. It just has to do with sort of litigation strategy.
If you know that your settlement with Company 1 sort of may become public and part of the trial record, what sort of gamesmanship do you think we might see? Do you think we'll see...
all the same gamesmanship there is now. Because I think everyone now assumes that there is a risk that settlements are going to become public. And so, what do? You try to structure, if you're the plaintiff, if you're the patent holder, you try to structure it so the royalty percentage looks as high as possible. How do you do that? You construct some very artificial royalty base and you say we're going to apply a relatively high rate to that artificially small base, and then you get a number that the defendant can live with because the defendant doesn't care. So I think there's a million ways that these things get structured to try to make the optics better. But I think everyone now assumes that there's at least a risk if you're entering into a settlement agreement that it's going to be disclosed.
Before we take if you don't mind, there's another area, another type of licensing arrangement where I think the discovery issue is very important, which is many of these standard essential patents are licensed under obligations to be reasonable and non-discriminatory. Well, how do you know if you're getting a non-discriminatory arrangement if you don't have access to what other people have paid? Doesn't that compel that kind of discovery?
I think that's a great point.
So, sort of a corollary ethical issue for Judge Huff and Earl. How do you keep past client confidences if you are required to disclose a confidential settlement agreement from a former client? If I'm in-house counsel, that former client, you are definitely going to hear from me until I get this resolved in my client's interest. Where does the balancing come in?
I agree. I think it's very problematic. And so probably in your current ones, that at least under RescueNet, one sentence in the sentence, in opinion, this court observes as well that the most reliable license in this record arose out of litigation. On other occasions, the court has acknowledged that these settlement things are really not very helpful. So at least for your current ones, you might put in, we're settling this in a notification to your client that if some crazy court says that it has to be disclosed, it might be disclosed, and then you could either intervene, your client could intervene and try to contain the damage, or make it attorney's eyes only, and hope that all of the participants follow the protective order.
Right, I think most of these settlement agreements or license agreements have a provision that requires notification in advance of production, and you wind up with somebody intervening. I mean, as I said, we did in this case, to try to protect the confidentiality of the agreement. But obviously, I mean, if the court orders you to produce it, you're going to produce it. You're not going to say no.
Well, you could say no, but then you might risk contempt. And that, in some ways, that is sometimes how people have attempted to litigate and get the issue before. Thus far, the Fed Circuit has not weighed in, but really, RescueNet is fairly well confined. And yet, courts have been reading this very broadly.
I agree, and I also think it's interesting that RescueNet didn't even really say, we find this settlement agreement to be highly probative. It said, relative to all of the other evidence, which we think was not probative at all, this may be the best. But I don't think it tells you whether it ought to pass the threshold, sort of considering the prejudice on the other side. I mean, there's not a sort of analysis of what the policy trade-offs are of requiring parties to disclose settlement agreements.
As a matter of case law, if you happen to be in the Sixth Circuit, that's the only circuit that's recognized a privilege to settlement negotiations. So if you're in the Sixth Circuit, you're in pretty good shape. The others, it sort of depends on which district court you're in front of.
Yeah, if I can go back to the Fran situation again, though, I wonder whether in an interpretation of Fran, someday we're going to have to figure out what that means, whether one of the determinations that courts have, or somebody has to come to, is that you don't have, that there should be transparency in the licensing, otherwise non-discrimination is simply not definable.
I think that's a great point, and I think it's a very good argument that sort of having the FRAND obligation gives rise to the transparency obligation too. You know, in light of what Brian was saying about it is jurisdictionally, and then Julie will get to it, but it's jurisdictionally super dependent where you are in terms of how judges, I think, are going to think about this question of the admissibility or the producibility, the discoverability of settlement agreements. You know, in the Eastern District of Texas, a bunch of the judges there have been not only ordering the discoverability of settlement agreements, but also in some cases the negotiations leading up to those settlement agreements. I think the theory being that you can't really test the settlement agreement without understanding what went into it, but boy, from a litigator's perspective, talk about stuff that starts giving you heartburn. I mean, you're going to run into mediation privilege very quickly, right? So we know in California we have an incredibly expansive mediation privilege. It covers anything said, you know, if you're touching mediation, you can't even sue your lawyers for malpractice if the malpractice happened in a mediation. So isn't it going to be the case that if you're thinking about entering into a license agreement, you do it under cover of mediation and then argue that renders everything non-discoverable?
Yeah, I think, you know, what you're saying is so fascinating. First of all, I'm so happy that we're done with the rule of thumb, and I'm so happy that the entire market value rule has been clarified from the sloppy language with which it was initially articulated. But the problem that we see over and over again is a search for proxy.
Yes.
And the reason we're searching for proxy is because we don't want to spend the time in court to actually hear probative evidence about damages, because the lawyers spend an awful lot of time fighting about liability, and then they leave this teeny little amount of time in an already tight schedule for damages, which always comes at the end. And now what are you going to do if you actually have to explain something? Much easier to say, here's a license agreement, it's 5%, over. This is all a search for proxy. In my mind, the real economic analysis that needs to occur is, what is the value of this component to the overall product by survey evidence, which is the only really good evidence to tell the value of that, I believe. What is the value of this to customers? And then, what would be the next best alternative that the infringer has? How would that lessen the value, and how much would it cost the infringer to do? A design around, and is it really doable? In other words, how much would they pay for it? How much would the licensor be able to extract from it? at the time of infringement, not now when network effects have made it, a RIM situation where it's impossible to get the, genie back in the bottle.
I can tell you that that's just going to prompt a lot of, practice pointers, Gilbert motions, challenges to the evidence. Your
Yes.
survey was bad, my survey's better.
Absolutely, absolutely, and
Yeah,
judges are
great
going to
idea.
have to, it is, but if this is a truth-finding mission, I mean, if we don't really care, seriously, if we don't really...
He's laughing.
Well,
Yeah.
I think your comments are just spot on, and, what we do now is, literally, we do the equivalent of searching for the dollar under the lamppost, because that's where the light is, even though the dollar's somewhere else.
The only problem, I agree, Julie, with everything you said analytically. The problem is searching in the dark is expensive. That's the other reason that we look where it's light.
But
And
it's
one of
not.
my worries is, patent litigation is expensive now, and actually that's one of the things that skews these licenses. One of the reasons that they're not that useful is because litigation cost can skew the amount of money people are willing to pay. This in some ways makes that even worse. If now I've got to pay for a survey expert too, in addition to my already fairly expensive economist.
Good value, though, good value.
I hear what you're saying, but I think you'll also find that this type of analysis will drive the cost of litigation down. And the reason I believe so is because it will put some rationality to patent litigation will no longer be a bonanza jackpot.
Yeah.
Right? And it will put some rationality to what the damages are, closer to what reasonable people would have actually licensed for, thereby encouraging reasonable behavior before you actually have to go to a jury.
But it's the illusion of precision, where, if you can go out and find a number, and that's a number, you can use that number. Of course, it might be a meaningless number, and you don't know what to multiply it by,
Right.
and all of that. Whereas what you're talking about, and I do think it's the right thing to do, it's unlikely to give you a specific number. It would come out with, well, we think something in this range
Right.
is reasonable. And that might be harder to actually, convince someone if it's a range. But I do think it's the right thing to do. There are other ways to do it that could achieve some precision. If you have lots of devices that are selling for different prices and they have different features on them, you can pretty easily statistically sort out what the values of the different features are. And then that says, well, that's what this feature is worth. And then you say, well, how many patents are on this feature, and what else goes into this feature, and it's a good starting point.
I'd like to suggest that surveys are not the only answer. I think there's a clue in Judge Rader's Cornell decision about creating a hypothetical sale price for a component. He says, look for the smallest physical structure that contains the patented thing, and then ask, if this were for sale, what would it sell for? There are methodologies that can be useful. There's one called hedonics or hedonics.
That's just what I described to you, so the hedonic regression.
Yeah, so I don't think you have to rely entirely on the consumers. You can go to the experts and say, what is the hypothetical selling price of this thing if it would have been sold by itself?
Yeah, right.
A couple of very quick observations. One is there are many cases where survey evidence is going to be very difficult to get. So if, for example, the patent is on some feature in a transistor, I don't know how a survey evidence is going to help you at all in almost any case. Secondly, there's a problem, with all due respect to Judge Rader's analysis in the Cornell case, there's a problem with also being the party who frequently makes the smallest thing in the product, I'm with Intel. There's a problem with looking at the smallest device or unit the thing is being sold, because you still fundamentally are going to, at some point, get down to some block in there, and it's some feature that makes some improvement, and it's also the other thing that has to be taken into the context, which there's been a little allusion to, but not a lot of thought, in my view, put to this, is the patent case inherently becomes the case about the patent in suit. Most technology products in the IT and communication space, that's one of hundreds or thousands, or some people have said hundreds of thousands, of patents involved in the product. And how you translate that into an evidentiary, a jury fact finder typically, and not have somebody stand up and start talking about, okay, here's patent 1, here's patent 2, which I don't think any district judge I've ever met would be willing to tolerate. You know, how you do that and get a rational context out of that is not clear to me. I mean, it's the patent system was originally established with the idea of one product, one patent, in essence, and there's some industries where that model still works well. There are other industries where it's really moved beyond that, and how we get to a rational system of, other than putting up economists, and there's some issues.
Inherently irrational.
System. You know, whether you're going to get to that is a real problem. I don't know how you do it in the context of, in addition to which, having a Seventh Amendment.
Right. Well, it's obviously a very challenging thing to do. I threw out a suggestion. I didn't mean for it to be an answer, but a suggestion, which is to think about the case as if it were part of a patent pool, so that you're not litigating this patent, rather you're litigating the value of intellectual properties generally for this device. And imagine it being licensed like you would license, you know, the MPEG technologies. And then think of all the patents that are essential for that technology and say, well, you know, you can't all have all the value. So some kind of implicit apportionment seems almost inevitable. Exactly how you do that, obviously some patents are worth more than others, some are more valid, likely to be valid.
And I'm probably simple-minded, but I'm thinking, and I've got to do that and infringement and validity in 5 days.
Yes.
Right? I mean, I think, I think part of the challenge, that, I mean,
Subject to
rigorously.
exception for extension for good cause shown.
Right. It's, but I think, Rich, that's exactly right from sort of in terms of like the Platonic model of how you would do it. I just wonder how practical in the courtroom it's going to be to come in and say there are 200 patents that potentially apply, and now let's look at the relative contributions of them and how does this one stack up against the other 199.
But couldn't you have your expert do that? And so then your expert could kind of put a summary. I mean, they don't have to do every one in front of the jury, but I do think you could have a good person say, I've done it, and then I've concluded this one is in comparison to this worth X.
So one of the issues that I think is now at the fore is really how you manage the case in light of the damage issue. In some cases, it's not going to drive the case, but we know in at least a substantial and growing number of cases, it is the driver because people are essentially being extorted to make some kind of nuisance settlement, rather than go ahead and incur all the costs associated. And so we're seeing at least some judges experimenting with trying to try to put that into the early case management. So it'd be interesting to hear your thoughts, Judge Huff, and also Darylyn, on how feasible that is. And I want to add one other element to it. This survey area is completely new to the patent law. I mean, it just hasn't been the tool of choice. I think it is going to be used increasingly. We have experience in trademark law, although trademark law has very different stakes, and it's usually not about the money. It's usually surveys to determine whether the trademark is valid. But it seems to me that you might want to try to push the sides to maybe agree on a survey methodology that could be sort of done in a collaborative way. I realize these parties don't get along, but the problem with survey evidence is that it is sort of the most questionable from an evidentiary standpoint. I mean, it's pure hearsay, and it's very hard to go back and replicate it. And so it seems to me that the courts ought to be trying to say, well, listen, we ought to agree on what evidence needs to be gathered. We ought to do it in a way that both sides have some involvement so that, we're not going to end up with fights about the quality of the survey. And in fact, there may be ways of trying to simplify that process. But I don't claim to believe that. I just think, it's going to be a choice that you face, and you're one of the more.
One of the good things about the patent pilot courts is that we'll have this little test model. and that we'll be able to share information and data, and then we'll be analyzed statistically about whether the patent pilot judges are doing things any better or not. But clearly, Chief Judge Rader has, and the Federal Circuit has said, please respond to the two big criticisms. Patent cases take too much money and take too long. Is there something that we can do to try to simplify that? And so I do think through case management there are things that can be done, and I like your suggestion, if they're going to do a consumer survey, to at least, maybe they want to do each their own, but agree on a model. So you're not fighting over you did it this way and you did it this way. That makes a lot of sense to me. And then I also think that in our court, we're talking about changing our local rules to add in a better process for the Gilbert challenge. We have really good, now, fairly certain ways of doing Markman, and so you know what you're doing, but the Gilbert, who knows? Do you give, like Judge Rader did in the Red Hat when he sat in the Eastern District of Texas and he found the expert not to be reliable? Do you give us a mulligan? Do you give a second bite? Or do you say, hey, you knew what you had, the rules are out, sorry, you have no expert, and you're just done. So those kinds of things we're talking about. Should we be able to let the parties test their frivolous theories with expensive experts, and then if one gets knocked out, do a do-over? Or should we say, all right, you may have one chance to remedy it? So those are things that we're talking about, setting at least a timetable for Gilbert challenges, so you're not doing it during trial. That's the worst possible time to be doing it.
I love that idea, and I love the idea of having the idea of Gilbert practice with respect to damages issues kind of built into the model. I was at a conference recently where I participated in a mock argument on a Gilbert issue directed to damages, and there were a number of judges in the room, and we did a little survey after and asked people how many judges had ever granted a Gilbert motion directed against a damages expert, and I would say 1 out of 10 raised their hand.
That surprises me too, which is, given the quality of some damage studies out there, it's really quite amazing.
But I think there was just a sort of still a kind of a reluctance to apply Gilbert. And I actually had an interesting discussion with one judge who said he preferred to deal with these issues under 402, 403 rather than under Gilbert, because he felt that it was a more flexible standard of review. And so he had more discretion in sort of dealing with expert issues just in limine rather than Gilbert. I'm merely reporting. I'm not, but I just thought that was sort of an interesting perspective. So I think having it sort of be a little more regularized and having it potentially come earlier.
So I think that there are going to be, different buckets and different, you could identify what the major buckets are and where damages could go first. Just one last comment, as Judge Huff knows, Chief Judge Rader is convening all of the pilot judges, and I hope you'll go to that.
Yes.
But, perhaps this ought to be one of the topics that gets discussed. I haven't seen an agenda.
Another topic, Judge Robinson in Delaware bifurcates damages. But in our court, at least, I'm not going to say never, but we're 3/4 criminal, 1/4 civil by having 2 jury selections, 2 opening statements, 2 final arguments. That's a significant percentage of the total trial. So it really doesn't work with 2 juries, because also the damage jury needs to know something about the technology. So that one doesn't seem to work really well. What does seem to be more attractive is the staging of the damage discovery. But I think we're going to be talking about all of
What she says, though, I think, is that they never actually get to the damage trial.
Oh, I see.
Right. I mean, that's right. I think what she... Yeah.
Before you go, I just want to ask you a question. Would you agree that if you can do it, hedonic analysis would probably beat a survey?
Wow. I mean, the areas where it's been applied. You can get really broad ranges. And so, I think it would require substantial retooling for this purpose. I don't, you would know better, but
Well, I think it depends on the
I
product.
think you could get some.
Depends on the product.
Wide
Yeah,
range.
right. Before we take the next question, can I carry on something you talked about, the cost and the speed of the transaction and making these things more efficient? It's, in a way, it's kind of scary, because I think of my experience at justice in merger cases. Every year we get, the justice and FTC get thousands of merger cases. And yeah, I mean, you can dispose of them very quickly. A lot of them are disposed of very quickly, and you can dispose of all of them by just saying, what's the HHI, what's the increment in the HHI, and you're all done. But is that the way you want to treat a serious merger case? I don't think so, and I don't see why these complex patent cases are any easier than a serious merger case. They do take time. They're complicated. And at one level, having a long, complicated, drawn-out, difficult case raises the stakes and means that you're not going to go to court unless there's some significant stuff at issue here, and that's a good thing in some ways. What's the bad thing, of course, is the nuisance patents. If I can make another real estate analogy, it's almost like, the analogy is almost like you walk by someone's apartment and the guy comes out and says, "That'll be $50, please." You say, "But I don't live here." It's $50, please. Give me the $50, but I don't live here. And that's okay. If you don't like that, there's a guy around the corner. You can talk to him, and it'll cost you $200 just to talk to him. So maybe you'll just reach out and say, "Here's the $50." Now, if there were a way to deal with that, life would be better. Unfortunately, we have very limited ways to deal with that, and it goes, I think, into antitrust and this whole business of objectively baseless in order to bring a case against the assertion of patent rights. But that brings us into a whole other area.
So I'd like to go to a comment that you made, Mr. Gilbert, about if you could identify all the patents that cover a certain product, right, then allocate the value to it based upon its pro rata contribution. And I think that's a wonderful idea, but I would say that if only the world were that simple. Because when we look at a product and we try to determine all the patents that may cover that product, particularly in the software space where when you're looking at patents, those patents do not provide a lot of notice and clear boundaries on what they cover. I would argue that that's a nearly impossible task. So what we're oftentimes left with, never mind trying to find all the patents that cover something, when we're discussing settlements and so forth, we are making decisions without knowing the entire sphere. And it's just...
Yeah, I did not mean to indicate that this is an easy task or maybe even a doable task. It is rather, what I'm thinking of is the importance of acknowledging that this is not the only item at issue. And that's, to me, a very big difference, because in addition to what you say, and I completely agree with what you say, you also have the issue that some truly essential patents are actually worth more than other truly essential patents. Even though they're all essential, some of them may be essential only for this product, while others might be essential for any product that's in that whole space. Some might be much more likely to be valid than others. So it's a very complicated problem, and it is. I would be the first to say you can't just add up all the patents and divide. That's silly. And if you could do that, then what you would see would be people patenting left and right and taking all the claims and putting them in separate patents. And some of that gamesmanship goes on in patent pools. So I clearly do not want to indicate that that is an easy thing to do. I just think it's important to get us off the notion that somehow when you're in a litigation over two patents, that those are the only patents that are involved, when in fact you could be in a space where there are 150 other patents that are as good as those two patents.
I wanted to get to something Rich was saying about sort of that there are cases that warrant the kind of very detailed economic analysis that you're talking about, and cases that don't. That's clearly right. They exist on a spectrum. I mean, it's not that we have sort of meritorious cases and we have frivolous cases. I mean, we have both of those, but there's also a whole spectrum, and part of the problem is sorting out what's what early in the case. And one of the reasons I really like the early Daubert idea, or the earlier Daubert idea, is that if you can get a sense earlier in the case of what the damages analysis is going to look like and what it's worth, that can also help with case management, I think, and other ways of trying to streamline what the proof is going to be so that the scope of the case is sized to what's actually at issue.
And this is good for Rich and those like Rich that are experts. It used to be maybe the thought from trial judges is that damages were kind of an afterthought, but now for practitioners, you've got to get your damage people in right at the get-go and be working hand in hand all the way through the markman, through the claim construction. If it goes this way, maybe the damage has to go over here. You've got to get the best information when your witnesses are deposed. They're going to be locked in once they're deposed, and then maybe it's going to be difficult for you to shift gears on afterwards. So the message is that now you have to spend a lot more detail with your expert reports have to be much more substantial. They just can't be, well, here's the number and this is what I think. You have to have some actual analysis that when you go to the trial judge, who probably has no patent background, maybe a little patent background, that it's going to make sense because we do these cases, but we do other cases. And so there's not really special rules for patent. You still have to have damages that meet sound economic principles. And so if you have really good experts that can explain that to the judge, then that's very helpful.
Great idea. Great proposal.
So to kind of close the loop on the patent pool thing and the small saleable unit, I think, Rich, you have a really good idea, and I think the way to overcome Michelle's problem is to first focus on getting down to the smallest unit that encompasses, that contains the patented invention. And then within that, you can also go even further. I mean, it doesn't have to be the entire Intel product. You know, there can be components of it, and you can say, well, if the entire Intel product costs $120, this is about a fifth of it. You know, get down as small as you can in the hardware space, and then start to talk about, okay, if there were a pool on this particular, you know, transceiver functionality in Wi-Fi, or return addressing in Wi-Fi, the way these cases actually, then you say, okay, there are about 200 patents, 400 patents. There aren't 20,000, 200,000 as there are on PC, and so those two things could kind of go together to get to something rational. But the reason I stopped with something else, and that is, there's this notion now that the damages will be the incremental value contributed by this invention, represented by this claim, over all the prior art. And the notion is that you'll have this hypothetical negotiation, which at that time you would sort of negotiate. Well, do I want to go that way or do I not? The fact is, in the tech space, most of the claims asserted against us were granted long after the design decision was made to go that way. And so you've got holdup built into most of these patents. Mm-hmm. If you say, date of first infringement, when you first started selling, making or selling, it's so far past the design decision. And sometimes past the date that you were selling it. I mean, these claims are issued after we've been selling this thing for quite a while. How do we deal with that? How do we get, the hypothetical negotiation back to a time when it would actually represent the value that this invention is, and not hold them back?
What do you think?
Wouldn't it be great if we could do it? If we could accept the notion that absent willful infringement, that the hypothetical negotiation should be when there were choices about what technologies you could use, not when you're locked in. I mean, once you're locked in, it doesn't matter if it's a standard or not a standard. You're locked in. There's not much you can do about it.
Yeah, that's why we need to insert some principles into the data. Yeah. Start to talk about what does the word reasonable mean in the context of what we're all doing. Step back from can you use a settlement agreement or not, and get a little bigger picture about it and say, what should a reasonable royalty be on one of 500 patents on Wi-Fi, which is one of 20 features in this computer, and furthermore, these claims actually were written after Wi-Fi came out and were drafted to be keep on it.
Yeah.
What is reasonable in that circumstance?
Right.
And let's open up the dialogue a little.
Question of who should get the patent.
What are we rewarding? What behavior are we rewarding here? What is a reasonable reward for that? How much should you get to tax a product that you wrote your claims to be on top of, that got nothing from you? You contributed nothing to it.
But
All you did was get a patent that reads on it. By 11 years of continuation practice and watching the technology develop and changing your claims as it went, and then popping out and saying, hey, guess what? You owe me money on that. What is reasonable in that circumstance? And I think that's where we need guidance from judges and ultimately from the Supreme Court as to what does reasonable mean?
Well, your question is a very deep question that goes to what goes on in the patent world.
I think it's something all people in this room need to think about and need to insert through your litigation.
There certainly is a belief that, particularly in these very complex technologies, that a lot of patenting takes place, in a sense, post-invention, not pre-invention. That's not the way the patents are supposed to work.
So we've been talking about the reasonable royalty rate being some function of the incremental value added by the patent. So I'm curious how that interacts with network effects when, the patent might be on a particular small function of the overall device, but there's some network effect associated with that function that actually causes that patent to add a significant amount of value. And even if we get to maybe a tipping point in the industry, then that might interact further with the entire market value rule, where the entire market value of that device might result from this very small patent on a very small part of the overall device.
I think that's a great point. You also have examples of industries where it may be more important, even if you have a patent that is ostensibly on a relatively small feature. Competitively, it's really important to be at the technological forefront and to have all those features in order to be able to compete. That may not be true in other industries. So I think the network effects are important, and I think just understanding the competitive landscape can be important in understanding what it actually would be worth to someone to be able to add whatever that feature is to their product.
Well, I think the question raises a number of issues. One issue is, to what extent should the technology get the credit for something that is actually the result of a network effect and could have happened to any technology? Now, at one level, if I have an invention that saves $1 on every product, then the value of that invention is $1 per product. Now, it may be because this particular invention is adopted in a technology that instead of the sales of 1,000 of these products, it's 1 billion of these products. So I don't get $1,000, I get $1 billion. It's a lot better to get $1 billion. But it's still worth $1, and it would seem to me that at most, anyone could claim is that it's $1. It's per unit. But it does raise the question: should it be less because of this network adoption? Now, this really comes up big time in the concept of what is fair, reasonable, and non-discriminatory, the FRAN circumstance, where sometimes you have I think many of us have argued that the proper, correct definition of a reasonable royalty is what would have been negotiated before the standard issue. Now, some people have replied and they say, well, look, after the standard issues, we have this wonderful technology, and we were responsible for this wonderful technology, and shouldn't we get the benefit of this wonderful technology that's out there? Well, the technology is wonderful because it was standardized, and it doesn't seem to me to justify raising the royalty rate because you got the benefit of the standardization. You get the benefit of the standardization through the volume, not through raising the incremental value of the royalty. So it comes up in that context as well.
But sometimes the reason for the standardization might be that particular, whatever invention is covered by that particular patent, right? I mean, it's not necessarily always just an accident of
No, I'm assuming that's the case, that you choose a technology that's patented, but then the question is, what is the reasonable royalty for that patent? And should it be increased because now it's, it's in everybody's device, and and it has more value, as opposed, and I'm making a distinction between that and the pure hold-up value of switching to another standard.
And it may be the case that at least when it comes to the entire market value rule, this may be a place where surveys are more useful than they would be otherwise. I mean, it may be the case, as Peter says, that maybe survey evidence is not that reliable, but it seems like it would be reliable enough to decide whether it was the entire basis, the only reason that people bought the product, or whether there are some others.
But it has to be survey that was taken before the standard was set. I mean, now everybody would say.
Litigation.
Right.
I'm sorry?
Which makes it impossible, right, in the real world.
In litigation.
Yeah, I mean, what you could do, well, at that level, I mean, what is done, actually, what is done is you go to the people who participated in the standardization committee, and you ask them what were the other technologies that they were considering and how much were they willing to pay for them.
And depending on whether they won or lost, you may get very different answers.
So
That is true.
less people feel that there's anarchy out there. I do want to say that
There is.
that I believe in the jury system, that it's the best system in the world. There are some other models for patent valuations in other countries, and maybe we could tinker with ours a little bit better and hold down the costs and make it a little faster. But I do think through our adversarial process that the discussion that we've been having all day can bring these things to light, whether the trier of fact is a judge or a jury, and that the litigators need to recognize who is their audience going to be, and then tailor those arguments and the evidence to that audience. Plus, there's many, many checks and balances, because whatever evidence is presented at the trial then goes to the jury, then has post-trial motions with the court, then goes to the Federal Circuit, and then can go to the Supreme Court. And even the Supreme Court, you've seen over the past, say, 5 years, is having some policy issues on what is patentable, what should we give this exclusion to, or what is not, as a society measure, kind of the issues that Peter Manel brought out. Should we give this right to exclude everybody from the market? And so my conclusion is still have faith, and that if we, the trial judges, are doing something wrong, then file really good briefs and tell us how we can do it better.
Judge Huff, if you go back over the history of patents, there are many episodes where patent rights threatened to destroy industries. Patents were almost destroyed the railroad industry, patents almost destroyed the aircraft industry, the telephone industry. But in each case, there was some legal response that reined them in one way or another. In the case of railroads, I think a very important decision was whether the individual inventors had the rights or whether the corporation had the rights, and then there were changes to how much the damage calculations were, yada, yada. And so my question is, are we going to do it now? Because I think we are in a crisis.
I think we are doing it now.
And are we fixing it?
I think we are. I think the Federal Circuit said no more 25% rule. They said trial courts, don't let any theories come in. You got to be very careful about the evidence. The American Invents Act, it's got its pros and cons, but at least it's a process to try to then have some better systems. And maybe some of it has nothing to do with litigation, but is maybe funding the PTO better at the get-go so that patents are issued when they should be issued and not issued when they shouldn't be issued.
We also have to get the PTO off the notion that their client base are the inventors and not the public. There's a social interest at stake.
Probably worth mentioning before we conclude this panel, we've been sort of proceeding on a premise that reasonable royalties can't exceed at least the expected profit on the accused product, which is something that's not necessarily supported by Federal Circuit precedent, right? We have the Go-Light v. Walmart case. The reasonable royalty is, what, almost $32 when the expected profit of Walmart is $8. We have the Right Height case where Judge Nice says in dissent that the reasonable royalty is more than the price of the patentee's product, more than 75% the average price of the infringer's product, and more than 33 times greater than the infringer's net profit on its entire machine. We have the Monsanto cases where the reasonable royalty exceeds the entire purchase price of the bag of seeds. So again, if there's one place to start, it might be changing some of that precedent.
I was going to say, that's right, although two comments on that, Brian. One, I think a lot of those cases can be explained by evidentiary defects in the evidence that was presented. And second, it goes back to the point that there's two sides to the transaction. I mean, there's what makes sense from the licensee's perspective about how much they'd be willing to pay. But there is also the question of what makes economic sense for the licensor. That doesn't explain all of the cases that you mentioned, but I think part of it stems from the fact that you do have to look at both sides of that transaction. And in some cases, you may have a circumstance where there is no license that it would have been economically rational for both sides to agree to, but you still got to pick a number.
Do we have any more questions from the audience?
Can I just follow up on that? It's very interesting bits of information. I would think that in the case, what you raised, where the damages can be very large, more than anybody would be willing to pay, would be a case where you are practicing the innovation and you just don't want the competition to be doing what you're doing.
You're either practicing it directly, or even if you are not literally practicing it, the entity that is practicing it will have some competitive impact on you. I think that's right. That's the circumstance where you're going to see it.
Right. Now, but in that case, you wouldn't generally be looking at a reasonable royalty. Wouldn't you more be looking at lost profit?
Well, you know, maybe not. I mean, there might be reasons in any given case why you think a reasonable royalty model makes more sense. And I'll give you an example in a pharma situation. I mean, the answer may not be we would have endeavored to keep this product off the market. Maybe it's a life-saving product. Maybe there's reasons you wouldn't want to make that argument. So you might, and maybe the competition is a little bit indirect, so it's going to be hard to break it down and actually show lost profits, but nonetheless, you could make a pretty compelling argument that sort of at a high level, there's a negative competitive effect on you from having this other drug in the market, and that ought to be taken into consideration in what you would have been willing to take in exchange for a license.
Well, I suppose if we don't have any more questions, we can go ahead and start the reception a few minutes early. Is that sort of late on Friday afternoon? Yeah.
Sounds like
Yeah, so why don't you join me in thanking our panelists for coming today?